Of duty under the State Government Act to avoid, or Ethics Act, to avoid conflicts of interest, appearance of conflict, and are instructed to refrain from participating in any matter coming before the subcommittee with respect to which there may be a conflict or appearance of conflict. Having seen none, I would defer to Brian to give us a kind of the overview.
Right. Thank you. Well, thank you everybody for taking the time out of your Friday afternoon to join us as we talk about this issue. So this inquiry is one that we received. I know Deanna just joined the call, and she and I have talked about this because I know she's received some calls about it, but we've also on staff received some calls about this idea, and it was one that we wanted to present to the ethics committee for I guess consideration as far as potential opinion, or is this going to be I guess that's the whole question. Should we even issue an opinion on it? Because I know I think there's a specific scenario that we can address, but there's also kind of a ripple effect that this particular so the issue, of course, is that we've got a situation where essentially a doctor that wants to create, or some other allied professional, the opinion references a doctor, but essentially call it a doctor that has in their office a list of potential lawyers that the patient can receive, or that the patient could contact with regards to obtaining legal services, and it kind of, the scenarios and the opinion spiral from there. There's kind of a question at first about whether a lawyer can agree to be included on the doctor's list of preferred lawyers. And I think that's going to kind of be a question that we'll need to discuss as far as, well, how many other lawyers are on that preferred list? Is it just, this is my list and it is one? And really, what are the implications of doctor saying, hey, I think you should get legal representation. Here's a list of individuals that you could obtain services from. The other opinions address kind of evolving scenarios, such as can the lawyer kind of pursue inclusion on a preferred list? Perhaps a doctor or other medical provider does not have this type of list available at their office. Could a lawyer reach out and say, hey, doc, I just want to know or want you to know about my services and let you know that I'm here and readily available to your client's needs. And as far as obtaining any sort of recovery if they've been injured by an accident or so forth, what can a lawyer do there in that scenario, or how can they initiate this type of conversation? And then I guess the other evolving situation that you see in inquiry number 3 is that again, doctor is really initiating the conversation, suggesting that the patients contact a lawyer, and particularly this lawyer, to ensure that doctors' invoices for treatment are paid. And then even beyond that what happens if as has been described to us, that some providers may refuse to provide services to clients unless they get a lawyer, saying, hey, you want treatment, for your injury? Well, I'll treat you, but let me first ask, do you have a lawyer? If not, then perhaps I'm not going to treat you at all, or perhaps I'm going to structure the payment. I'm going to demand payment up front, or we're going to have to do, monthly periodic invoices that you have to keep up with. Otherwise, if you have a lawyer, I'll give you full treatment and I'll just trust to get recovery from whatever recovery you obtain in your own pursuit of legal action. Does that create a coercive sort of scenario that's really unacceptable under the rules? So those are kind of where it starts. I feel like there's probably a number of different inquiries that could also be attached to this. I know litigation funding is one that Deanna has encountered with folks saying that, these litigation funding companies, they may reach out to folks individually just to say, hey, if you are looking at legal action, I just want to let you know that our company is here to provide the financial resources so you can pursue your legal action. Also, here's a list of lawyers that you can retain, or, maybe, I don't know if it's as much a, you must choose from our list, as opposed to, here's some suggestions if you're looking for a lawyer. And if you obtain services, or you retain one of these lawyers, then we'll be able to give you this loan for your litigation funding. That's another inquiry that I think is kind of out there that we can flush out a bit more. But I'll just kind of start there as far as this is the overview of kind of the conversation. I know at the October meeting when we talked about this, I think Amy, you made the point that there's you started getting into the ripple effect, that this is something that a lot of folks do. I think one obvious one that comes up is, all the different lenders that are out there, mortgage lenders, that they've got a list of approved attorneys. Would this opinion impact that? Because we do have an opinion that does permit lawyers to be on that approved attorneys list. And just kind of, I think this is one of those things that this could be a bit of a sticky issue. So we need to be sure to navigate through those different issues. But overall, that's where we're at. And I guess we open up the floor for discussion.
Brian, do you know off the top of your head that opinion number? I didn't know there was one on lenders.
Now, of course, I don't have it right here. I have not
Okay.
pulled it up just
I may
yet.
try and pull it up while we're on here, just because I didn't know it existed, and I'm curious to see how we handled it and whether that gives us any guidance for this one.
I'm gonna look for that right now. And I know I feel like it's this is not her job, but I know Deanna has an encyclopedic knowledge, and she's on here too. If Deanna, if you feel like giving us a shortcut to exactly what number it is, then feel free to let us know.
I think Deanna always just sends her logo. I'm not sure she's ever really here.
I know she has a lot of stuff going on.
I'm here.
I
Sorry.
was kidding.
I think it was the ethics opinion. Seems like it was like 97 FEO 8. It was one about a developer, and the developer regularly uses an attorney, a specific attorney. And I'm not certain that that's it. I'm going to pull it up here in a second. I'm trying to get to it. But I think that developer insisted that the closing take place using the seller's or the developer's attorney. Is that what you were thinking of?
Yeah, I think I might be looking at or thinking of RPC 57. It's from 1989.
Okay.
That the opinion says that a lawyer may agree to be on a list of attorneys approved to handle all the lender's title work. It's kind of one of those things, and that's kind of this ripple effect of essentially being on a list that somebody else gives you. That this is an approved attorney, and we want people to select one of our approved attorneys. Seems
to me that that's distinguishable from a doctor who is treating a patient. We kind of tacitly accept that one lawyer is kind of representing all three, the lender, the buyer, and the seller in a residential real estate. He's got, at least has duties to all of them that they're answerable to as a lawyer. That's not really the situation where there's a doctor with or an accountant with their own duty to their own client, and they're just trying to get paid. That's different to me.
I think a lot of it has to do
I'm
with.
not saying it's wrong or I'm against it. I'm just saying I'm not sure it's really relevant to that.
I would think the conversation, the difference between, inquiry was 1, 2, and 3 is what type of conversation is happening inside the doctor's office. So it's, is it, well, I'm getting the runaround from the insurance company. What should I do? Well, you should call a lawyer. I don't see that as direct solicitation. I think that somebody comes in and they were like, well, I was in a car wreck, and then they volunteer, well, you need to get a lawyer so that I can get paid. That's pretty different than the first scenario. I do know that all 4 of these happen, in practice. I mean, we know that. That's why the inquiries are out there. there's a chiropractor in our town that, he does do different payments for people with lawyers versus without lawyers, because he knows he'll get more likely get paid if they have a lawyer than not. Now, I don't think he requires them to go with any certain lawyer. And I don't think that he, it's not that he's charging differently. He just requires them to pay out of pocket rather than letting them incur a bill. And I think that goes to inquiry number 4. And again, we're not on this doctor's preferred list, but we are, we haven't asked to be on the list at least. He may refer us cases, he may not.
Right.
We're just happen to be one of 2 firms that do personal injury work in this small area.
Right. Yeah, I think the opinion is written is pretty darn good, Brian.
Yeah.
Frankly, I don't know. I mean, you walk into any, this is translatable any number of situations. You walk into any, well, I don't want to characterize particular ethnic restaurant, but you walk into a lot of them, there's a whole bunch of lawyers, cards and stuff sitting on a little counter sitting there, such that, and who knows what the conversation was in order to get those cards on the counter, and what the conversation is between the owner of the, why do you have this lawyer? I mean, who knows what's going on there? As a lawyer doesn't know anything untoward. Seems to me it's not too much different than that.
I guess that comes back to, do we need an opinion? I mean, Brian, do you have a strong feeling on that? Whether this is something, the way it's working is not unethical, or do you think there are people that are currently on the fringes such that we need to give them a pass?
So I gotta say, my gut reaction is that I think that there's some guidance that is needed, because like what you're talking about, Warren, that's something I don't think any of us would have heartburn over. Just the notion of like, I'm leaving my cards here. That's, people do that, and that's
right.
That's not necessarily what we're kind of protecting against. But the notion of, I think when it introduces some bit of either kind of an inappropriate solicitation that the lawyer is aware of, I guess the general notion that a lawyer can't ask somebody to do that which they can't do themselves. And so, there's the question, of course, of somebody's doing this and I didn't ask them to do it. The doctor is improperly soliciting for me and I didn't ask them to do it. But essentially, if you are, if you become aware of it, are you kind of ratifying that? That was one of the rules I cited was 5.3, which deals with non-lawyer associates. Now, I think we've historically interpreted that as people who work in our firm, but you can see that there's the term folks that are, and I guess I don't have the exact language directly in front of me, but if the lawyer, basically we're talking about, I think the scope is both assistants that are employed as well as what you call independent contractors. If I'm contracting with an IT firm to handle all my IT business, I think a lawyer does have a responsibility to make sure that that IT firm isn't just selling all that confidential information that they now are kind of protecting. And so in that regard, if you have formed this relationship with a non-lawyer medical provider or other professional that's essentially engaged in improper solicitation, should the lawyer be held responsible for it if they know it's happening and they don't do anything to correct it? They don't say, stop, you can't do that. But then the other aspect is the coercive feel here, that, and Davis, I think your illustration is, it's that one that we have in number 4, that in some ways it feels to me improperly coercive, but in other ways I can understand, where the chiropractor is coming from, in the sense that I have no assurance that you can pay this bill, and I don't want to incur this bill that I know will not get paid. But if I know that there's a lawyer involved and that there's some sort of attempt to progress towards a resolution, then I'm not going to put myself in a really financially difficult position. That it's like you can look at it through a reasonable lens as well as the unreasonable lens, where it really feels coercive. And I know I was thinking about just the experience I had a couple of years ago when we closed on a house, and the seller was, it was a developer, and they said that, we've got a preferred attorney that things should go through. And basically, if you don't go with our preferred attorney, you won't get the keys to your house at closing. We're going to have to wait until everything else clears, the bank accounts and everything is filed and all that. And that might be, a few days to a few weeks. At which point I wanted to, start talking about ethics, and my wife told me to just stop being the ethics guy and just get our house done. But it still felt a little coercive. So all that's to say, I think those are the things that we could use some guidance on, because and it really kind of brings some awareness to me. The point of the opinion really, or one of the benefits of the opinion, whatever we issue, might heighten that awareness of lawyers to realize, if I've got some sort of working relationship with someone, I have a part to play here, even if that's just instructing the person, these are the things that I can't do, and I can't have you doing those things. Or the coercive nature, they get a client because somebody's refusing to treat them, offer medical treatment, unless they get a lawyer versus this lawyer.
Right.
That's a question I think that we have to figure out.
Yeah.
I think that's where some of the guidance needs to be having. And Davis, I guess you referenced, like, this stuff is happening. And I think that was one of the reasons why David Allen and I were talking about having you on the subcommittee, because I know this is part of your area of practice. So you've probably seen some of these things. So anyway, that's where I do think it would be beneficial.
Yeah, I think ultimately we're not trying to regulate the doctors and the chiropractors, we're regulating the lawyers. And right. So the lawyers, I think it's absolutely inappropriate for a lawyer to know that there's a chiropractor or a doctor out there that is saying, if you don't call this lawyer, you can't get I'm not going to treat you, or I'm going to make you pay full price out of pocket because I don't trust that I'll get paid back. I think that we should absolutely have guidance there that's inappropriate if it's not already there. The question I think that you said point blank is it a lawyer versus this lawyer? And so if I know that there's a doctor out there that's saying you need a lawyer to protect my lien, is ultimately why we want a lawyer involved, and I know that's going on. Am I required to turn down those clients that are coming to see me? Am I required to stop doing business with this medical facility altogether because they're doing, recommending a lawyer? They're having a different payment structure for people with lawyer versus people with not. And I think that's where it's a little more vague as to how we can provide guidance.
Right.
So Brian, I just have two questions to throw out. I'm learning a lot here, by the way. The first question is knowledge of what the lawyer is doing. Does that imply any duty? Right.
Yeah, I think that's a question. I've put in the opinion that I think there is, but I think that's debatable.
Yeah. And this is related. And I think the thing that I paused a little bit on was, this is a broader interpretation of 5.3C1 than I would have historically attached to 5.3C1. I view an independent contractor or someone who is a non-lawyer working outside of the firm, who is working with the firm, as differently situated than this doctor. So I don't know if that's good or bad, and I don't know what the ramifications of that are in different contexts. And I will admit, I just did the homework this morning, so I really haven't had time to think about it. But so that was my initial response.
No, I think, Ellen, that is you're really kind of hitting on I think one of the aspects that I was struggling with a lot. This was, and this inquiry was really submitted earlier this year. And I was trying to draft something, frankly, for July, and us internally, staff, we were really torn on what is the analysis. Maybe it's just something that you just say, listen, this feels icky. And I think that's kind of the reaction that we had. This feels icky, but there's no rule necessarily against ickiness. So what exactly are we talking about? And ultimately, again, that notion of, is there potential client harm that really necessitates an opinion? And there is potential client harm in the sense that if a client is being directed to a particular lawyer, even if it's like 3 lawyers, here's my preferred list, you pick one of these folks and I will not bill you. Does that resolve it? That's something that, I'm talking with Deanna earlier, apparently Ohio has kind of given their blessing on that type of model, that as long as there's at least 3 lawyers on the list, that it's not going to be any type of improper solicitation or anything, because the client ultimately gets to choose. I don't know if that's a magic number or just, what was the rationale behind that number, but still, 5.3 kind of occurred to me when I was looking at the language that just, the introductory, at the outset, it says, with respect to a non-lawyer employed or retained by or associated with a lawyer. And that last part, or associated with a lawyer, is kind of the part where I'm like, okay, is this an association? Is there something that lawyer is aware, chiropractor, doctor, whoever it is sending me business, I know that they're referring stuff to me. Is that an association? I am very broadly interpreting that word. I recognize that. And that's where I wanted to hear everyone's opinion on that. Because I think it's reasonable, but does everybody else agree? I think it's, I'd love to hear everyone's thoughts, because I think the ramification is that if they're not associated with the lawyer, then 5.3 doesn't apply, and you can't say that lawyer is really responsible for the person. You may have some sort of solicitation issue or coercion issue, but that really does require, I think, some action on the lawyer's part to really kind of direct, or be complicit in that solicitation and coercion to kind of implicate the rules. Without that, if it's just that, I know this is how the doctor acts, I didn't tell him to do it, I heard that they're doing it, but that's not me. Perhaps that's the answer. And it feels icky to me. I don't love it, but I don't know if the rules allow a different answer. So anyway, I know I'm talking in circles here, so I'm going to stop talking.
I just think there's a big difference between, I think the starting point is what my first point was kind of the vagueness of how the conversation arises. And that's hard for us to rule on, like one way or the other. But I think that, a ethics, opinion that says, I do think that we could say without a doubt that if there's a doctor saying that you have to hire this lawyer or that you should hire this lawyer without being asked about it is inappropriate. If it's one single relationship, because I promise you, there are relations out there between bad firms and marketing firms that do a lot of bad, that aren't the best lawyers, and independent medical facilities that have those one-on-one relationships where there's not a preferred list. They may call it a preferred list, but there's one person they're going to send to. That happens. And so then your next inquiry goes back to the billing stuff. I think we can absolutely say that that's inappropriate for them to require you to go to this lawyer or they're not going to treat you. So.
How do you govern there being more than one person? Like how do you monitor? How do we enforce? How do we make sure if you're on the list, there's nobody else on the list? I mean, that's where the number issue becomes a problem for me. And also with the limiting to a number or requiring a minimum number for where Davis works, he says there's 2 firms in town that do it. So
Yeah.
As opposed to where I am in Charlotte, where, you have hundreds of choices. It feels like picking an arbitrary number won't work across the state either.
And there's plenty of other firms that come here. They're just not from here. Plenty of Charlotte firms that creep here.
They're the worst. They're the worst.
Well, I don't know how you govern the number. I don't know how you deal with small, rural areas, but I think if you put a number on it like that, and then I think what happens is the market has to govern it, right? In other words, the lawyers have to say to the doctors, I cannot do this unless X, because this is how I am regulated. And then the doctors make the market decision. I'm going to do it in that way so I can get paid. Now, I'm not saying that's good, but I think that's how it ends up. I would assume that's what's happening in Ohio. I don't know. I don't know how else. I'm with you, Amy. I don't know how else you could do it.
And I think the thing that we really can regulate is the backroom deals where it's one-on-one that, realistically, only the lawyer and the doctor know that it's out there. So that lawyer knows that they would be in violation of this. And it's not going to come up unless a client brings it up to some other law firm or to someone else. That's something that we can directly regulate and have an opinion on that says you can't do that. You can't have a one-on-one deal where you get all your patients to come to my practice and I will get, I won't reduce your bill, X number of dollars. There's ways that, that lawyers can adjust their fees, or they can adjust, paying some provider, not following the lien statute exactly to make sure that the chiropractor gets paid more than, or a certain doctor that refers to the case gets paid more than others. And that can be manipulated. And so I think that one-on-one deal is something that needs to be, that we can regulate.
Mm-hmm. So I guess maybe if I kind of looking at the opinion, inquiry number one, is just kind of the inclusion on a preferred list. And the answer is yes. The opinion says that the answer is yes, provided that doctor does not engage in improper solicitation. And that's kind of relying upon other ethics opinions that are out there that say stuff like, a lawyer can provide business cards, provided that they are essentially unaware of the professional engaging in in-person solicitation, kind of straight up walking up and saying, hey, you need to have this. Is if you leave the business cards there for collection by the client, or for the client to simply walk by and ignore that, that's going to be okay. So I think that's kind of, maybe if we just start there with just can you be included on one of these preferred lists? And do we think we need to have a number, admittedly arbitrarily selected here? That would be, but also meaningfully, in the sense that you're ultimately trying to ensure that the client has the knowledge that there's more than one lawyer out there. But I think still the prohibition on in-person solicitation is appropriate, but it's just a general, can I be included? Maybe we just start with that first inquiry and see, do we all agree that yes, you can be included?
I agree with that. And I have a hard time trying to articulate why we should pick a specific number. The main thing is that we're trying to avoid is quid pro quo, right?
Right.
Yeah, more than one is really what we're trying to avoid.
And even where the doctor may just know one lawyer, and that, as long as the doctor's not saying only go to that lawyer, the doctor says, I know a lawyer who's pretty good, you might want to call him. I don't see anything wrong with that either. Or why we should get into worrying about that versus the coercive thing that Davis is talking about, where it says, if you go to this lawyer, I'll treat you. If you don't go to this lawyer, then I won't. That's very different than just say, I know a good lawyer, especially, Davis's community. Like you said, there's not very many in-town lawyers there that do TI work. So,
right.
The choice is what's important, I think.
Yeah, just
having a choice.
choice. They're, you know, saying, I know a lawyer is different than saying, go to this lawyer.
Yeah, the choice takes the coercion out of it.
Yeah.
So, do we think that it's okay for I guess we're talking right now about just like, you know, yes, you have a choice, and maybe even if you say, I know this particular lawyer, whatever however that conversation evolves. But as far as who initiates it, does the lawyer, I guess, put it this way, does the client or potential client have to say, hey, you know, do you know any lawyers, before the doctor is allowed to say, there before the lawyer is allowed to agree to have a doctor provide the information? That's where, you know, we start getting all this who's saying what. But should the client essentially initiate the request for information, or can the professional provide that information directly to the client, you know, on their own initiative? Are we okay with?
Well, if we're going to allow the whatever preferred position to exist with the lawyer, and with the lawyer knowing that the doctor might be adjusting how he bills based on whether you have a lawyer or not, then it's going to come up from the doctor's perspective when they start talking about billing. When you're ready to leave the office, whether you get charged for that day's visit or whether you are allowed to, you know, not, you know, get a bill later on. So that seems to me it's necessarily going to come up in that scenario if that's the arrangement that we allow. And I'm not saying there's anything wrong with allowing that. I'm just saying and it could come from either direction there.
Yeah.
Yeah, I would say that, you know, not to be cynical, but I look at the insurance company pretty much as the enemy in my line of work. I mean, they're trying to pay as few claims as possible and accept all their premiums. That's their business model. And a lot of people don't know they need a lawyer. And so I think that a lawyer reaching out directly to somebody is completely inappropriate. You know, we don't do any direct solicitation stuff. But I think if, you know, they're talking about stuff and a car accident comes up and, you know, maybe they don't ask, do I need a lawyer? Who would you recommend? But maybe they just, you know, say, well, I can't even get a rental car. You know, something like that comes up. That's why I'm saying this conversation is so vague as to how it would come up. I don't see anything wrong with somebody suggesting, well, maybe you should talk to a lawyer. You know, something like that. And just as a friend or as a treater, rather than, you know, it's not a lawyer running down there to do it. But I don't see anything wrong with it.
And I don't see how lawyers would know. You're never going to know that conversation between the doctor and the patient because it's also protected. And you may say to the doctor, if we put attorneys in a situation where we say, you can't have the doctor raise the issue if the patient doesn't, we'll never know if it's happening. Like there's no good way to police that. I don't think that's fair to do to lawyers.
No.
Ellen, I see your hand is up.
Like David said earlier, I'm sorry. Go ahead.
No,
Ellen.
go ahead, Warren.
Warren, she
go
raised her hand. Have manners, Warren.
I'm a teacher. I can't help it. Go ahead, Warren.
I was just like David said, these conversations are happening all the time right now. Anyway, the question to me is just this idea that the doctor has a preferred list, that the doctor talks to their client, to their patient at some point about whether they should get a lawyer or not. It's that they have some prepared preferred list that they hand to the patient. I'm sorry. Go ahead, Ellen.
No, that's okay. So I think we should also consider that we're thinking of this coming up in one fairly narrow way. And I think the way medicine is practiced today, it's very likely to come up in more ways than a private conversation between a doctor and a patient in a room, right? And so I could see this on the form that you fill out when you are doing your online intake at the computer in the office, or the one that you fill out online before you actually get to the doctor's office where you're checking in, and there's a question that says, do you have insurance? And you say no, but you've said you're there because you had a car accident and you have a neck injury, and then it then leads you to, right? So I don't think that should change our I'm a slower thinker than you all are, I think, but I can't think of any problem with that during this conversation. I would have to think about that, but I do think we have to recognize that it's probably not just going to happen in the way that we're thinking about it.
Sure.
A lot of times where it'll come up is where the injury is a little more severe and they need an MRI, for example. And so their health insurance won't approve it because maybe a chiropractor or maybe they've had an MRI within the last year because of pre-existing issues, and it won't get approved by their health insurance. They don't have any money, and so they need a law firm that has resources to get MRIs performed to do so. And the doctor's going to say, well, you might need to contact a lawyer because you need an MRI, stuff like that. That's where I see it coming up a lot, where they get to the MRI stage and then they realize that it's more significant. They need an attorney to walk them through it.
And I can tell you that every set of chiropractor intake, medical record intake forms I've ever seen always have, do you have a lawyer? If so, who is it? Every single one.
There's probably some law firms that the chiropractors won't work with.
Yeah.
Because they're less likely to get paid back then.
So I want to talk, I think we're still on one, and I guess Warren said something that made me think, what does list of preferred lawyers mean? Like the question is, may lawyer agree to inclusion on doctor's list of preferred lawyers? Are we talking a formal list that gets handed out? Or are we talking about, I know Joe and I know Sue, you should call one of them? Like, what does preferred lawyer list mean? Is that something we want to explain, or is that way too into the weeds?
No, I think I think you're hitting on kind of like this might be a bit narrower, than because we're talking about,
Right.
An actual written list, and perhaps more so, can lawyer agree to be, I guess it's almost recommended, and I guess by the doctor. And I think the answer to that should be yes, as long as there's no quid pro quo. I
think that's right. And if you know a doctor has a list and you want to get on that list, you ought to be able to
send him money. Is that what you do, Warren? You send him
no,
money?
you just ask.
Good thing we're not live stream. Oh wait, no.
I think that would be inappropriate money.
Right.
I think that it needs to be based on,
Just kidding. I'm sorry, Davis. I'm just kidding.
I'm just kidding.
Right.
Kevin's like, this is the first subcommittee I'm chairing, and darn it, it's going off the rails. No.
Can't put me on anything.
I mean, if I'm in Davis's town and I want to open shop over there, I'm going to go to every provider and say, hey, I just opened an office over here. Know about me.
Yeah.
I mean, if I'm going to be doing that kind of stuff.
So it sounds like, and I think, maybe what I'm hearing, I'm trying to kind of get the overall answers to the questions and kind of figuring out the tweaks that we need to make. I'm kind of thinking it probably would be appropriate to reframe opinion number one, as opposed to, we can use the list of lawyers as an example, but really what it boils down to is, can lawyer agree to be, kind of included in the doctor's recommendations or recommended lawyers, the group of recommended lawyers. And I think it sounds like our answer is yes, as long as there's no quid pro quo. Now the details of that is, we get into that in just a second, as far as, whether we want to reference 5.3 or anything like that. But it kind of, I think, goes into what you just said, Lauren, Warren, number two. Does lawyer have the ability to pursue that conversation of saying, hey, this is me, these are my services, I'd love to be somebody that you would refer people to? And that the answer to that is, again, yes, as long as that doctor is not really engaging in, a quid pro quo, or and of course we have there for no improper solicitation. I think that's really where it starts to get kind of a little fishy of what are we considering improper solicitation. And is that something that we think can, reasonably be policed or known because like Davis was saying, this is, and Amy was saying that this is talking about a conversation that's occurring outside of the lawyer's earshot. There's I don't even know if it's worth it to say that, yeah, a lawyer can be recommended by one of these professionals, and can even initiate to be recommended, but should lawyer just kind of at the outset caution or inform the doctor that, hey, I just wanted you to know I'm not allowed to engage in in-person solicitation, and I'm asking you not to engage in in-person solicitation on my behalf. Maybe that's something that's just not. I don't want to say it just may not be practical to actually put that sort of parameter on, because we don't. That's something outside of the purview of the rules. We're talking about somebody else's conduct. I don't know. What do you all think of? Is there enough of a nexus essentially between lawyer and doctor to actually say, lawyer, you can be responsible for the in-person solicitation that occurs?
Well, I think if it's a list situation, it's not really an in-person or an in-person solicitation that the lawyer wouldn't be allowed to do. That would be similar to a lawyer walking up to someone and saying, here are 5 business cards of local lawyers who may be able to help you with this problem. As long as it's not the just one person on the list, it seems like you're also avoiding the in-person solicitation that could get the lawyer in trouble.
Does everybody agree with that?
Yes.
All right, my next question is kind of going back to something that Ellen brought up. Do we think doctor is associated with lawyer such that lawyer could be responsible for doctor's conduct? And under 5.3C, I guess the thought process, the analysis is that if lawyer becomes aware of some type of misbehavior by doctor and does not correct it, that lawyer could be held accountable. Is that a bridge too far?
I'm uncomfortable going that far for a couple of reasons. Number one, there might be all kinds of different, sort of agreements between the doctor and the lawyer. There's a difference between having a prepared list that has, these are the lawyers you should go see. I'm recommending these lawyers. I know them. I know their work, that kind of thing. And then the other scenario where the person asks, I don't know of a lawyer, and the guy just picks up a list of 3 lawyers and says, oh, these are 3 lawyers I know do this kind of work. Go ahead and call one of them or somebody else. And I don't have good comfort sort of trying to govern both of those at all, or regulate both of them.
I think that goes back a little bit to something Davis mentioned earlier, which is also these conversations are had one way or the other, and the only 2 people that know about them are that provider and that client. So you may even be on a list and not know about it. So if that provider is making inappropriate contact with folks, I wouldn't want us to have an opinion that can hold an attorney accountable that's on that list and they're not even aware they're on the list. Or you take that action and you talk to the doctor and say, look, I've heard you're doing this. You can't do that. And they say, no problem, I won't do that anymore. And the next day they keep doing it because you can't functionally stop that.
I think the distinction between this and the normal 5.3 situation for me is the client confidentiality. Like, the doctor has their own set of confidentiality with the patient Whereas if we're supervising a paralegal or a title searcher with that outside of our office, that's a different, the client doesn't have that same, they're either on the same side or don't have that separate confidentiality relationship. But that bothers me a little bit in the doctor context.
That's a good point. So I think, oh, go ahead.
I was saying goodbye to Deanna.
So I think if we're looking at it like this, that, essentially if it sounds like we're saying, if lawyer discovers doctor is engaged in improper solicitation, doctor is just straight up, as soon as they walk into the room with the patient saying, hey, before we get started, I got to tell you, do you have kind of that thing? Do you have a lawyer? No. Talk to this guy. Talk to these three, these two, whatever it may be. Even if it's just, here's a list, but I'll tell you, this person right here, number 3, that's a good lawyer. I know this person. I think you should call them today. That would be something that I guess we're saying the rules really can't regulate that, because it's the doctor's conduct. And again, the notion of whether a lawyer is even aware it's occurring is not something that we can really hold the lawyer accountable for, the actions of someone else that, to Amy's point, has a separate set of privilege and confidentiality in their own interactions. So perhaps that's where the inquiry number 3 and opinion number 3, we ultimately say that or the opinion says that the doctors engage in improper solicitation, but it relies upon 5.3 to say that lawyer is kind of associated with doctor, and therefore lawyer needs to say, doctor, you got to stop if they learn about it. And if they don't stop, to just kind of like withdraw their inclusion on the list, and maybe or maybe not. That whether that actually happens is going to be dependent upon the circumstances there. Would we want to eliminate that one? Is that something that the answer is lawyer doesn't have to take any sort of action because that's the doctor's conduct, and lawyer is not responsible for doctor's conduct?
I like that. I mean, unless there's some, that's why I kind of got lost trying to discuss a minute. I mean, if you've got an arrangement with a doctor to do something that's against the rules, then you've got an association. But if you've got, right, you've made it an association by basically telling the doctor to do something for you that you know is against the rules, whether the doctor knows it or not. But if you tell the doctor what you want, what the rules require, and otherwise follow this opinion, I don't see why you have some duty to ask, clients when they come in that were referred by that doctor, well, what did he say to you? How did it come off? Because if for no other reason than people go home from doctors and lawyers all the time, have no idea what they were just told ever, and misconstrue it and misunderstand it. I mean, it's just, I don't have a good feeling for giving you a duty to find out what that doctor's saying.
Right.
I think number 3 would be very tough to enforce, very tough to, just in the wording of it, is like, we can't hold an improper solicitation. A doctor's can't be held to the same definition of that a lawyer is, because of what we've talked about earlier. And, I think we can really fine tune number 4, inquiry 4, and make something of it though, that can cover what we're concerned about, which brought up number 3.
So do you think, and just to flesh that out, do you think there's any responsibility for the lawyer to provide any sort of kind of instruction with anybody who they're going to be on, just to say like, hey, don't improperly solicit. I can't, the rules don't apply to you. They only apply to me, and they're not even going to apply to me through you. But I'm just saying, generally speaking, in terms of legal services, it's bad to do this. Or is that that might just be too wishy-washy to say in an opinion. I'm not saying that because I like it. I'm just trying to see what you all think.
You
I
might be
don't know how
right.
you enforce it.
Right.
I just don't know how you.
I'd say if, the very small caveat would be if you like affirmatively reach out to a provider. Like a lot of times you're on these lists because of relationships between you and you've done business with the doctor, you've worked on, he's treated your clients before, but you never really reached out to him. And so there's like hey, we're doing business together. This relationship's okay. I think that if you move to town and you want to go meet every one of these providers and take them to lunch or something like that, then maybe you should. I mean, I wouldn't see I think it'd be hard to enforce again,
Right.
A universal rule for it, but I don't see anything wrong with saying, hey, I want to be on the list. I don't want to be, have a quid pro quo here. And I don't want you to do anything that I would deem unethical, which would include, sending letters to people in recs that aren't even your patients, stuff like that. But if they come into your office to be treated, they're looking for help. I think it's hard to regulate.
I'm trying to pull up an ethics opinion right now. I've referenced this in the opinion. It's early in the opinion, but it's 2007 FEO 4. That is the business card opinion, the one that you can provide business cards and for distribution, so long as the lawyer does not understand, the professional will engage in-person solicitation. So it's kind of like I guess I interpreted from that opinion, and I don't know if we still agree with this, that there's some sort of, I don't know if I'd say a duty to inform, but there's some sort of, I guess maybe it's at least just being confident that the doctor isn't going to engage in in-person solicitation, that makes you able to provide your information to be recommended by a doctor. Again, that may just be an unworkable sort of thing. And because I feel like we're heading towards an answer here in opinion number 3, that essentially would be, the response to the question, what action, if any, must lawyer take in response to learning about doctor's actions, that being in-person solicitation? The answer is essentially, unless lawyer has instructed doctor to engage in the in-person solicitation, lawyer does not have any responsibility to correct or otherwise disassociate.
Rather not have 3 in there than have 3 in there and answer it that way. I just think it leads down a path. It's not really what we're intending, but I understand why you'd have to answer it that way if we leave it in there.
Right.
Don't we have in other opinions things like, while the rules don't require it, best practice would be to talk to the doctor and say, please don't do that?
Yeah.
I mean, to at least to sort of deal with that icky feeling that we have, as opposed
What
to.
if we just prefaced the whole opinion with something that sort of talked about the no quid pro quo? Yeah. Remember, you can't have somebody else do things that you couldn't do for yourself. And while this below may not be a direct 5.3 situation, just at the outset of one of these relationships, if you're going to initiate it, and obviously there are circumstances where the doctor's just picking people he knows, but if you're going to initiate it, keep these things in mind as a best practice.
Right.
I mean, it doesn't give you any teeth to enforce, but I think it makes it clear what the bar expects from you if you're soliciting this type of relationship.
Right. Yeah, no, as I'm looking at this, I think we can set the parameters that are consistent with that prior ethics opinion that we're, as we have in inquiry and opinion number 1, just to say, yeah, it's fine to be on this list as long as you don't understand the person will be engaging in in-person solicitation. That's it. That's consistent with what we said before. That's just kind of and we could just remove inquiry and opinion number 3.
That's what I was wondering, is if we could just tune 1 and 2, if we like the language from 2007, and almost get rid of 3 and 4 and say, you
I
can be
like
on
that
this
too.
list as long as there's no quid pro quo and you don't understand their in-person soliciting, and you
Right.
can seek out to join that list as long as there's no quid pro quo and you do not understand that there's in-person soliciting. And
Yeah.
that seems to cover all the questions we've had.
I like that. If for no other reason, I don't want to give a roadmap to bad actors to work their way around something, right?
And that, Warren, honestly, that's one of the hesitancies that I had in this whole thing. That, do we even want to issue this opinion? Is this going to be exactly what you just said? Is this going to kind of outline, well, how do I get around this?
Right.
Give ideas of what to do. And so I think what we would potentially add to what Kevin just said, that there's an understanding that there's no quid pro quo, no in-person solicitation. 4 really brings up the coercive nature of this discussion. And so I think we could reasonably include in that retooled sort of approach that coercion also. If you don't understand coercion is involved, then yes, you can be included. The thing that we're not doing is answering the question of, well, if you discover coercion was involved, what are you supposed to do? And that's the one where the in-person solicitation is one of those that I'm with you on, kind of like, how can we enforce that? How are we going to know that? All that stuff. But the coercion one just makes me feel really icky. And I don't know if that's just something that we have to live with, because again, this is, whether you're talking about in-person solicitation or some sort of what I would consider kind of a really just inappropriate sort of coercive proposal, maybe that's just something that's not within this opinions and the rules purview. What do you all think?
Well, and maybe it's not yet, right? Maybe what we learned from this issuing 1 and 2, and again, I'm new to this, so I don't know if this is like a proper process, like thinking process for the bar, but maybe if 1 and 2 are issued, right, it may be that we discover in 2 years that absolutely the way this is happening in Anson County is an association, right? And we clearly understand that this fits under 5.3 and there's things that doctors need to be doing. I don't know, just sort of I'm not usually one for the common law approach, but maybe that is what we need here.
Like there's a difference, a preferred list where the doctor has a list of, and you have to go in and try out for it, and then sign some agreement that you'll be included on their preferred list, and that you've met all these parameters and things like that. That might create an association, but we'd have to get into how many different iterations of inquiries in order to cover all the things between that and I'm one of 3 attorneys in town that do this work. Will you put me on your preferred list? And then at what point, and rather than try to do all that, concentrate instead, like Kevin said, it's the quid pro quo. It all goes back to that. You just can't do that. And then we'll figure that out from there.
Brian, I'm going to say it, but what about how does this apply more broadly? Like, you've only included medical doctors. What if it's counselors? And there's been some sort of trauma. Or you're following up from some sort of accident that had medical, they sent you to a counselor, you're at the counselor finds out you don't have a lawyer. And that's still saying within a semi-medical field, but I still have concerns about how this is applied across the board with regular other industries or professionals that recommend lawyers.
Yeah. No, I think that's where, unfortunately she had to drop off, but Deanna's question about litigation funding came in, that they'd be an allied professional, and there are activities, my understanding is that they are engaged, or some of them are engaged in kind of an in-person solicitation effort to contact folks. They see accident reports, see who's gotten injured, who's the victim. They reach out and say, we can provide you with funding to pursue your litigation should you need it. And when the person says, well, I don't have a lawyer, they say, well, here's some lawyers, or here's a lawyer. Some of them actually do well, let me connect you with a lawyer. And that's something that I know we're wondering, should that scenario be included? I did not include it in this opinion, but I'm wondering, is that related enough to include in this opinion when there's kind of maybe that's the direct, the professional's response is so specific to, you don't have a lawyer, let me connect you. Here's this one lawyer. Maybe that needs to be more explicitly stated as like, that is just not okay. Because you, in that situation, I feel like, I don't even know if I would say that's an association as much as that's kind of you are committing a violation of the rules through another person per 8.4A. And to kind of approach it from there, and we can leave 5.3 out of it entirely. But that's the sort of thing with that litigation funding thing where they're just directly connecting folks. That is incredibly problematic to me. The litigation funding saying, well, here's 3 lawyers. I don't know that that's really, I don't know that we can say that's problematic because they're still given a choice, and we can't really get regulating a company's word choice to some extent.
I'd prefer, if we are worried about litigation funding, we do something separate for them. I mean, that's a complicated, poking that bear. It's so complicated. I sent you something this morning that was really troubling to me about, the way litigation funding works. It's not just litigation funding for this case, it's litigation funding for this law firm, and it's tied to a bunch of different cases. And blah, blah. I mean, and how do those clients for those cases understand how that litigation funding in one case might affect their case? And it's juggling of different, I mean, I don't know. To me, that bringing litigation funding into anything gets really complicated.
Right.
And
I saw what you said. I had a snarky response in my head, but I refrained from putting it in an email. But I see where you're going, Warren. We're of same mind.
Yeah.
So anyway, okay. Well, I know we're at an hour now, so Kevin, I don't know. I want to respect everyone's time. I do feel like I've got some good direction on how I'm going to kind of revamp this opinion. And I'll send it to you. And I think maybe one of the questions I would ask you all to look at when reviewing whatever I send over is, does this opinion add anything? Now that we've kind of reached these conclusions, does this opinion add anything to what we had? Because before, when I said, I do think some guidance is necessary, I think we're looking at this more of a kind of a 30,000 foot view that I think is helpful and I think is accurate, and kind of, like we've said, just aware of the different issues, but and really the inability to address third parties' conduct. So perhaps this does add something, perhaps it does add guidance, and maybe it doesn't. So we'll just keep that in mind whenever I send that over to you.
I just wanted to add that I think I got to jump off, and I appreciate everybody's time, but what you're talking about with the funding, I've heard, and we've initiated complaints with the state bar on behalf of some lawyers in our community, but there's 20 different ways right now people are getting information from police reports and so forth, contacting injured people directly and then soliciting attorneys, and that's happening. And so I think we may need to, ultimately look at the direct solicitation opinion and revamp that to make sure that it covers third. I had one client, or my sister got a call from an insurance client that got called by an insurance advocate, and all it was a cold caller that was calling on behalf of one particular law firm that we filed a complaint against, that's out of Georgia but has lawyers up here in North Carolina as members of the Trial Lawyers Association and stuff. That stuff's all wholly inappropriate and needs to be reined in at some point, but I think that wouldn't be good for this specific one.
Okay. No, thank you, Davis. Well, maybe that's just a separate issue that we'll take up, and then this subcommittee will recommend the creation of a new subcommittee, a separate subcommittee, right?
Yes.
It's a
Please.
Circle of life.
Well, I got to go. Thank y'all, everybody.
See you, Dave.
Kevin, is there anything else that we've missed? How are you feeling?
I don't think so. I think we can adjourn.
Okay. I'll get back with y'all as soon as I can get something on paper and tell me what you think.
Thanks, y'all.
Sounds good.
Happy
Thanks, guys.
Thanksgiving. Bye,
All right.
everyone.
Thanks.